Welcome to the Napthans podcast, Debrief the Legal Podcast. I'm Matthew Taylor, Head of Family in Liverpool at Napthans. Today, in this episode, we're going to be looking at how families can protect their wealth, assets, and businesses as their families expand. I'm joined by my colleague Stephen McKellar, Senior Associate Solicitor in the Wills, Trust and Probate team at Napthans, who helps families prepare a wide range of support, including the preparation and amendment of wills, trust administration, and management of inheritance and capital gains tax. Welcome, Stephen. Thanks for joining me. So let's start with taking a look at what we mean when we talk about family and business wealth.
Absolutely, my pleasure. So, to start with, in terms of family wealth, you're looking at generally the money, the investments, the shares and assets that a family will have accrued over time or that a business will have generated for the people within that family. In terms of family wealth, that might be your main residential property, cars, jewelry, artwork, the bits and bobs you have around the house that might be worth a little bit of money or just sentimental value. From a business perspective, it would depend upon the business, whether that is shareholding in a limited company, whether that might be an interest in a partnership, or if you're a sole trader, the business that you're running in your own name.
Okay, so we've got all the assets that are underpinning the day-to-day life of a family and supporting their income, their expenditure, and their lifestyle. So
Exactly.
I think what we're going to discuss today really is looking at how that can change over time, because obviously families do change over time. They grow, they shrink, and things change. So the families can expand, older generations pass away, there can be divorces, there can be marriages, and family and business interests can then be moved onto the next generation with these intergenerational wealth transfers. So let's set out a scenario of something that's fairly common that we can maybe run through what people can bear in mind when they're looking at these intergenerational wealth transfers. So let's say we have a family company.
Mhm.
It's the shareholdings owned by mum and dad, husband and wife. They're in their late 50s. Their adult children are working in the business, and the parents are thinking, maybe I've worked hard enough. Maybe it's time to pass the baton over to the younger generation. I quite fancy that round the world cruise or whatever it is. So they come to see you, Stephen, and start to talk about how they can make the plans to do this, for shares to be transferred and ownership of the business to pass to the children. What are the things that you're advising them? What are you looking out for? And what should anyone in a similar situation who's, listening to this bear in mind?
Absolutely. Well, the first thing we normally discuss whenever someone comes in at any point to discuss potential transfer from one generation to another is how their will is structured. It's the start point for all further plannings to make sure that the will is up to date and correct and takes into account both the business position and the general family position as well. You'd be surprised how many people still have wills that are 20, 30 years out of date. They've not kept up to pace with where either the business has grown or the family has changed and the family dynamics have changed, whether that's children getting married, children having children of their own, and so on. That would be the first step, is to make sure there is a sufficient will in place. Now, that structure can depend upon what that person's family situation is, whether how old the children might be. If the children are still relatively young, the structure might look different in terms of what you're potentially passing over in the will compared to a child who's slightly older. If there are children who maybe are on a sort of rocky edge of a relationship or just about to start a relationship, you might want to consider a different structure, whether that's in terms of including a trust over some of your assets to separate out from potential risk of, as you're going to be well aware, divorce
Yep.
proceedings. The next step we'd consider would be what your tax position is. Whenever you're talking about an intergenerational transfer of wealth, whether that is after death or during lifetime, if, for example, the parents in this scenario want to look at retiring, how they can transfer those shares over in a tax efficient manner is a key discussion that we would usually have. The rules for inheritance tax of a business have changed. Prior to April 2026, your shares would have been exempt in general from inheritance tax, as long as it was a trading business. So, manufacturing company,
Mhm.
care home, whatever it might be, as long as you were actively trading, you had an exemption for inheritance tax. Nowadays, that position has changed, and each individual will have a £1 million tax allowance for their business property relief or agricultural property relief. When it comes to intergenerational transfer of wealth on that basis, when there's a business involved, we need to make sure that that's structured in the correct way so that when wealth suffers down the generations or filters down the generations, the wealth isn't going to accrue to too great an extent that might exceed their own tax allowances, particularly if people might not be well, or if there is a risk of divorce or other dispute within the family.
Hmm.
A trust structure might be an appropriate structure that we'd look at putting in place either in the will or during the lifetime to start filtering those shares or that interest in the business down to the next generation in a way that still gives them an element of control over the business. If the children are trustees of that trust, or if the parents still want some element of control when they're retiring, they can also act as trustees of these trusts. So it gives them a little bit of link in terms of continuing control over the company while starting to filter those assets down to their children.
So handy where there's some ongoing involvement in the company. It's not going to be a guillotine where parents are running the company one day and then not the next day. You have a transitional period. So presumably
Absolutely.
quite useful for the actual practicalities, because it's daunting, isn't it, for children taking over the running of the family firm. Sometimes that gradual transition can be a really useful thing. So it reflects the way that life works as well as something that's advantageous from a legal and tax perspective.
Absolutely. And maybe down the line, as the kids start to get more and more involved in the business, they take it over and run it particularly well. The parents might take a step back and say, well, we no longer want to be trustees. We're going to trust you in terms of running the business going forward. If you limit the amount going into trust, you'll have a £1 million limit that you can put in general. But if one of the children does divorce, or if they were to pass away, it avoids that £1 million excess from staying within their estate if they were to die, or from potentially being involved in the divorce proceedings if they were to break up with their existing partner.
So, what are the consequences if someone fails to do this and fails to consider this? Because presumably you can be looking at really sizable tax bills if you don't get things planned in the best way.
Well, absolutely. Take, for example, assuming that our business in this example was worth, say, £20 million.
Hmm.
If we were talking pre-April 2026, you would have had no tax likely on that business, assuming it was trading. Going forward, it's going to be a case of on the second death, assuming that they've done a traditional sort of will, they left everything to each other and then everything to their kids outright. On the death of the second individual, you could, in that circumstance, be looking at potentially a tax bill of about £3.8 million.
Wow. So, by someone not setting up the proper structures, you can be looking at a tax bill that's getting on for 40% of the value of the actual asset, which, and presumably that's got to be found cash wise in relatively short order, which, most businesses aren't going to have that sort of money floating about that's easily reachable.
Well, absolutely. And unfortunately, that tax bill does come very quickly after someone's passed away. It's usually payable within the first 6 months of death. Now, there is an extension that you can get over a 10-year period to pay in installments. But the problem with that is that interest continues accruing. And that interest rate can be quite significant. And that can very quickly add up. And trying to maintain a business while paying down an ongoing 10-yearly debt to HMRC is a pretty tall order for most businesses in general. So putting in place the correct structure in advance that mitigates that risk and starts to filter that generational wealth down during their lifetimes to try and avoid that large tax bill on second death is a more appropriate way in terms of saving general wealth within the family.
Is it possible for you to illustrate the sort of tax consequences if you put the scheme in properly? I mean, what are we looking at in saving that tax bill? Does it eliminate it entirely, or is it a case that it reduces it from what it otherwise might be?
Well, the starting point would be that we're potentially looking at reducing the overall tax bill. If we were to say on death one, rather than leaving everything outright to each other, and because we could always take it further advice at the time, depending on
Hmm.
what's appropriate for your circumstances. But if you were to start separating out some of the assets at that stage, rather than it all accruing to the survivor's estate, it stops that from them being potentially taxed on their death. And if there's been any growth in the value of the business between those deaths, that growth will have occurred outside of that survivor's estate. So it prevents the tax bill from potentially getting worse if it stayed within the surviving spouse's estate. It also gives, I suppose, a little bit of element of trust over to the kids, showing that there is that separate pot of cash that you can then look at filtering down within the generations, whether that's to the children or to grandchildren at a later date, depending on how long this trust lasts for, rather than it being a potential gift from the survivor. It starts that clock ticking much earlier. If you put the trust or some other gifting structure in place in the appropriate way during the person's lifetime, as long as they survive for 7 years beyond the date of the gift, it usually falls outside of their estate. So it's not a very quick fix. It's a longer term
Mm.
planning solution. Like a lot of things, whenever you're talking about intergenerational wealth transfer, it's a longer term plan.
Well, that's the key, to have the long-term view. And you talked about it at the start, is ignoring a will for 20, 30 years. You need to keep things under review. And as life changes, the protection measures should potentially change as well. So that, I guess, covers off the headlines on disposals on death. If we're talking about lifetime gifts, then are there any other considerations, perhaps, before I start to swoop in and talk about, I mean, this is just miserable, isn't it? We're talking about death and divorce and all the really happy stuff. But before I start to talk about how potential divorces and separations might impact this. So in terms of, lifetime gifts, are there any additional considerations there?
Well, absolutely. I mean, one side is loss of control over that asset. If this is an income generating asset that you need, gifting it away might not be in your best interest during your lifetime if you're going to need that income over a longer period of time. It might also depend upon where your children's position is overall. If you know that maybe there's some issue in the relationship that your child has with their spouse, or you know that they're potentially looking at getting married in the near future, there might be other things you want to have a discussion over, whether that's in terms of waiting to gift at a later date or putting in something, as you're well aware, a prenuptial agreement that would coincide with that wider gifting plan.
Yeah, well, that probably brings us on to my
Absolutely.
area, and so keeping it in the family, as it were. So it's not uncommon for me to be having conversations with business owners who are doing exactly, we'll stick with our scenario, gifting shares, often in trust, to children who are taking over the run of the business as they step back. There are a number of situations that can play out, and there are a variety of things that we can do to add an additional layer of protection, because if shares are gifted, if interests in family businesses are gifted to parties who then go on to divorce or marry, there are potential claims to the value of the shareholding that that party has on a divorce. Now, that's not to say that their spouse is going to get half the shares. That's a real rare occurrence. There are a
Mhm.
variety of reasons why that's not suitable really for anyone, and the court doesn't like to force that. But if a company worth £20 million is then divided into two, so each sibling has £10 million, well, if that becomes a matrimonial asset for one of them and they get divorced, then the spouse may say, well, that's £10 million in the pot and I need a £5 million account for that in some way, shape, or form. And while there are various arguments against that, the better thing to do is to avoid those arguments and set out an early stage that that won't be the case. So that's where prenuptial agreements come in and postnuptial agreements come in. Because on divorce, when you're married, there are claims against everything.
Mhm.
What a prenup or a postnup can do is set out joint property and separate property. And that's a really easy way to think about it, is it can say, these assets are joint property, so the family home. Potentially you've pulled savings together throughout the marriage, but these assets are separate property. And that might be any inheritances, family business that's been gifted, maybe an investment property that's been held since before the marriage. You can frame these investments, these assets, however you want. And you can then structure what would happen in the event of divorce. Now, hopefully you never use it. Hopefully it never comes to pass. But if you are setting out the principle which says that joint property will be divided and separate property will be ring fenced and kept, then provided certain formalities are complied with, and in brief terms, they are that both parties need independent legal advice. There needs to be disclosure, so you need to know what you are giving up your claims to
Mhm.
as the financially weaker party. And there needs to be, for a prenup, not for a postnup, but for a prenup, it needs to be entered into significantly in advance of the wedding. The guidance is 28 days. That's not hard or fast. But the general idea is that you're not standing at the end of the aisle, push a bit of paper and say, sign here, darling, or the wedding's off. So it's to avoid that duress piece, which feels very soap opera, but it's to make sure that people have got sufficient time to consider things. If you do that and the agreement is fair, then if it were to be later be challenged, and the idea is it's not later challenged because on divorce you both look at the prenup and go, well, we signed up to it, so we'll comply by that. But if it's not challenged, and if it's fair, then the court will say, in most cases, yeah, that's fine. Go with that. We're going to allow you to have autonomy. We're going to allow you to manage your finances however you want, provided that it's fair. And fairness in this context means that needs are met.
Mhm.
So predominantly that minor children their financial needs are met. They've got home with mum and home with dad, and whichever party has got sufficient income to be able to provide for their basic needs that are all relevant to the standard of living during the marriage. Provided that's done and the needs of the parties themselves, someone isn't left homeless, isn't left with nothing, then it's fine. So unless your prenup says someone gets nothing and someone gets everything, that's unlikely. A court's unlikely to look at that and think that's fair. But provided that there is enough, your needs can be quite a lot lower, and it can be a huge departure from the equality that might otherwise happen. So these are really key things, and they often work alongside the trusts. So you can then set up, if you have set up a structure, worked with sort of our corporate lawyers to do share transfers, and the shares are then held by a trust for which the beneficiaries are these adult children, it's very easy for me to draw up the document which says, well, this trust, the assets of the trust, and any proceeds, potentially income from the trust, is separate property which is to be ring-fenced, with a rationale that this is because it's not been generated by the fruits of the marriage, it's been generated from the family of one of the parties, and therefore fairness dictates it should remain with that party in the event of divorce to be passed down the bloodline, potentially to grandchildren, and so on and so on. So they're really, really useful. The other thing that needs to be considered is a cohabitation agreement, and this is for unmarried couples. So the laws on cohabitation are vastly different from marriage. On marriage, the court can attack anything it wants, basically. All the assets, everything's up for grabs and on the table. For cohabitants, there's really only claims in respect of properties that you've got an interest in, or you can establish an interest in, perhaps that you financially contributed to, or claims for minor children. So for a cohabiting couple, in that situation, if they separate and one of them has received assets from the business and holds these shares and runs this business, the claims against the business are going to be, they're going to be non-existent just from the basis of them cohabiting together. So you're sort of safe from that perspective. But this is where the other kind of intergenerational asset transfer comes in, which is the really common bank of mum and dad. Has there been a property provided? Has there been a deposit provided? Has there been any sort of contribution to the family home? Well, what a cohabitation agreement can set out is that someone should get their deposit back because it was gifted by a parent, or where the property's been bought outright, that remains in one party's name, and all these things. And that, again, is some extra protection. So if we go back to our scenario where we have these two adult children with the business of 20 million, let's say one is married and one is cohabiting and considering getting married. For the cohabitant, the advice there is postnuptial agreement. And even when things are going swimmingly, and it can be a difficult conversation.
Absolutely, I can only imagine.
It is very sensitive, and it's not necessarily the most romantic thing in the world. But I think most people, because that's what a lot of people worry about, is how to have this conversation. And actually, if you're happily married to your spouse, and your spouse knows that your parents have worked incredibly hard for this asset all their lives, 99 times out of 100, if you say, look, mum and dad are going to transfer these shares, but they've talked about a postnup, they will say, well, of course, I don't want to claim in those shares. That's yours. That's your family's. And they'll go to the kids. So, of course. So normally it's less of an issue than you think. And when there's an issue that is brought up, it perhaps makes you suspect maybe there are some other problems in the relationship, to be brutally honest. So having those discussions becomes, not easy, but perhaps more straightforward in more cases than you might initially expect. So for the married child, that's what you're looking at. For the other child, my cynical divorce lawyer advice is, well, don't get married, which sounds incredibly stark, but the claims on divorce are a lot wider than claims as cohabitant. So the advice is get a cohabitation agreement. If you've already bought the house and it's 50-50, it's joint names, you possibly don't even need one of those, although they can be useful in setting out a mechanism of who keeps the house or if it's sold on the end of divorce. So they're still useful. They're not as vital. But if there's an issue with the house having been funded, you might want a cohabitation agreement. You shouldn't get married, but people don't get married because of divorce. People get married because they fall in love and they want to be married, and marriage is a great thing. So the advice is then, well, before you get married, a prenuptial agreement, just to make sure everything's really clear. So that's kind of how they work hand in hand. So from your perspective, hearing that, does that kind of, how does that sit with the advice that you give and what clients are looking for from your perspective?
I think it's very complementary, really. And there are always more concerns that you need to address whenever there is an unmarried partner, because there's no similar tax saving compared to leaving a gift to a married partner. It's very similar in terms of the cohabitation rights, not the same as rights for married couples. It's the same in terms of inheritance, unfortunately. So it brings you back to the start where if you have an unmarried partner in there, you need a will to make sure that they're benefiting in some way. Also can be part of the conversation over how you structure that transfer of wealth, because if there is a potential child who has an unmarried partner and there is that risk of a potential divorce coming out because there is an issue over where the relationship might go, and if your advice would sometimes be certain people shouldn't always get married, then you might have that situation where rather than giving a significant value to that individual, which would then accrue to their estate, and if they're not getting married, there's no similar spousal exemption to delay that initial inheritance tax bill. Popping a trust structure in place that at least separates it out from their estate might be a better thing to consider. And again, it always depends upon the structure of the family and what works best for them.
Great. Well, thank you, Stephen. That's been really interesting and really helpful. I mean, wonder if we should just finish with what's the sort of take-home message that you want anyone who's listening to this to think about? What should they really be considering? What should they be focusing on if they're in a situation like this?
Absolutely. I think the first thing to say is have a look at your wills. It's always the starting point whenever treating over your. It's always the starting point whenever you're looking at how you're going to structure your assets and the asset transfers to the next generation. Secondly, it would be have a look at your tax position, because that will direct whether it's appropriate to use certain structures. Have a wider conversation within the family as well to see what works and where things might want to go. And then take advice from someone who knows what they're doing.
Yeah, I think that's key, and that's what it always comes back to. And it's early advice, and it's a lot more straightforward. It's a lot less adversarial, and it's normally a lot cheaper to take the advice early than it is to try and repair a problem. The thing that I'd add to that as the main takeaway for people is to keep these things under review. Going back to what you said right
Absolutely.
at the start, is these are not documents, whether it's a will, whether it's a prenup, whether it's a cohab agreement. These are not things that you lock away in a drawer. These are things, I think of the nuptial agreements as marriage insurance. And in the same way that you want to make sure that your house insurance, a payout would cover the rebuild cost, you need to make sure that it's still appropriate for your circumstances all the time. That's exactly how you should look at these nuptial agreements. So keep them under review and make sure they're current, because as soon as they get out of date, that's when problems can arise.
Absolutely. I couldn't agree more. It's a case of whatever you have in place now might not still be appropriate in 5 years' time.
Thanks very much, Stephen. If you'd like to find out more details on the support that Napthans provides families and businesses, along with a wide range of other areas, please visit our website. Thank you very much for listening and watching.